Rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, this honorable court. Please be seated.
Good afternoon, everybody. We have two cases on the docket today. I've already been introduced. To my right is Judge Eisnagel, and to my left is Judge Paige Kilbane. And you'll have 20 minutes per side. There's a clock on the podium with red, green, and yellow lights. Green means you still have time left. Yellow for the appellant means you're into your rebuttal time. Red means it's time to sit down. If we drag it on too long, we might give you an extra minute or so, but the 20 minutes on the clock is your total, so don't think you have 5 minutes after your 20. If you have any noisemakers, anybody, please put them on silent or vibrate, because they're guaranteed to go off at exactly the wrong time, and then everybody will be looking at you and pointing at you, and you don't want that. So, without anything further, we'll have is it Taya Crutch-Williams and the rest of the Williams family versus the Frains, and that's case 25-0491. And if you'll let me know how much time you want reserved for rebuttal. Typically we do 5 minutes, but whatever you want, it's up to you.
Thank you, Your Honor. May it please the court, my name is Henry Guy, and along with my colleague Karen Gievers, we represent the appellants, and I would like to reserve 5 minutes of time for rebuttal.
All right.
I first wish to say that there is our position that there's really only one issue for this court to decide. The issue is whether the adoption statute of repose, section 63-182, Florida statute, bars a civil action for money damages against individuals who are affiliated persons with a lead agency subject to the contractual requirements to the Department of Children and Families. When said persons are alleged to have used their insider positions within that lead agency to improperly influence the placement and treatment of a family and children receiving child protection and child welfare services in a manner that violated Florida law. Under both Florida and federal law, when said civil action is not filed within 1 year after a termination of parental right judgment is entered. Now, I want it to be clear that the civil action that is at issue here is solely a civil action for damages. There is no claim to change the placement of the minor child, and there's no effort to challenge any of the necessary elements of the TPR judgment. It is solely a civil action for damages seeking to hold the Frains, and that is a pseudonym, Carl and Jocelyn Frains, for the actions that they undertook while in their leadership roles with Kids First of Florida, Inc. Mr. Frain was a member of the board of directors, and in that capacity, he was heavily involved with the activities of Kids First and regularly signed documents on their behalf. Mrs. Frain was a foster parent mentor with Kids First of Florida. She was paid for that work, and she was also involved in the placement and modification of placement of children who were within the services of Kids First. So these two individuals are heavily involved with Kids First of Florida as a lead agency. They understood the contractual obligations of Kids First that it owed to children under its services, and those obligations were set forth in the briefs. The duties that were owed, well, first, before I get into that, let me get back to the first issue, which is the interpretation of 63-182. The issue is, in this case, is that the trial court improperly determined that any kind of civil action, if it related in any way to a termination of parental rights, would be barred under 63-182. And we would assert that that's just not the case based on the plain language of the statute. The statute in its entirety says, notwithstanding Section 95.031 and Section 95.11, or any other statute, an action or proceeding of any kind to vacate, set aside, or otherwise nullify a judgment of adoption or an underlying judgment terminating parental rights on any ground may not be filed more than 1 year after entry of the judgment terminating parental rights. So by its language, it precludes an action that seeks to vacate, set aside, or otherwise nullify a judgment of adoption or the underlying termination of parental rights. We cite in a brief the definition of those terms in Black law, from Black's Law Dictionary. The term vacate means to render inoperative, deprive of validity, or void or annul. The term set aside similarly means to annul or vacate, and the term nullify means to make void or render invalid. Thus, the only question is, does a civil action for damages vacate or set aside or nullify a TPR judgment? And the answer to that is it doesn't. It's a civil action for damages. The jury's verdict, in that case, assuming the plaintiffs win, will have no impact on the placement of this child, no impact on the findings of the termination of parental rights or the adoption judgments. It is a civil action for damages, and the only question is whether there is a cause of action against the Frains. In their briefs, the Frains try to emphasize the word any as an indication of an expansive scope, but their argument divorces that broad term from the express limitations placed upon it in the statute. Section 63-182 does bar any action or proceeding, but only if that action seeks to vacate, set aside, or otherwise nullify a judgment of adoption or the underlying terminated parental rights, which is not the case. We think that this court should be guided by its own decision in Manny versus MBB Engineering, Inc., which is 273 Southern 3rd, 214, which this court was interpreting a statute of repose regarding construction design defects. And in that case, the plaintiff had sued a inspection company who she had hired to inspect a house for her and determine if there was any construction defects. The inspection report said that there were no construction defects. However, more than 10 years later, she discovered that there actually were construction and design defects in the house, and so she sued that inspection company. The inspection company asserted as a defense that the claim was barred by the statute of repose 95.113C, which barred any claims founded on the design, planning, or construction of improvement to real property. And the trial court agreed with that and dismissed entered a judgment on the pleadings. This court reversed and essentially held that while the job that they hired for the contractor for to inspect the home and determine whether it's a construction defect clearly related to construction design, it was not an action founded on the design, planning, and construction of the improvement to the real property. So essentially, he said that the statute of repose must be interpreted strictly by the plain language within the statute itself, and if that language does not encompass the specific cause of action that is asserted, then that action is not barred by the statute of repose. That is inconsistent with Florida Supreme Court law, which I will quote Hess versus Philip Morris U.S. Inc., 175 Southern 3rd, 687, Florida, the 2015 Supreme Court decision, which basically says that statute of repose must be strictly construed, and any ambiguity, if there is any, should be construed in favor of the plaintiffs, which is consistent with the Florida's constitutional right to access to the courts, and decisions reflecting that any limitation on a party's right to access the court should be strictly construed in favor of access. The other case I would cite to this court regarding the interpretation of 63.182 is its own decision in Ambrose versus Catholic Social Services, which is at 736 Southern 2nd, 146, which is a 1999 decision of this court. In that case, the plaintiff had adopted a child, and she wanted to sue Catholic Social Services because that child had developed some mental and psychological problems. And she had alleged that during the course of the adoption proceeding, the lead agency and agency's agents failed to disclose that they had information from the father that he had mental depression issues. And so after the adoption, she sued, and the the defendant asserted that the claim was barred by the statute of limitations. And this court basically said that the claim was not barred, or at least there were factual questions remaining based on the complaint that couldn't be resolved on a motion to dismiss, and it allowed the claim to succeed or proceed. The critical issue is that that action would also have been subject to 63-182, and this court did not conclude that the plaintiff was barred from filing suit based on that statute. This court recognized that a civil action for damages based on...
Counsel, what's the most outrageous fact on the emotional distress claim?
Well, I think
from your
there's
perspective, I'm moving on to the other issues, right? Wasn't there an alternative holding from the trial court that on the emotional distress claim that the allegations were not outrageous?
Well, if you read the court's decision and and dismissing the third amended complaint, what the court said is, if you exclude everything related to the 2017 dependency proceeding, then I don't believe there's sufficient facts to support an intentional infliction of emotional distress claim. And what I would say, or in response to the court's statement, is that the first issue is the court improperly excluded the allegations related to the 2017 dependency. And then as far as the outrageous conduct itself, if you take the facts and allegations in their light most favorable to the plaintiff, which this court has to do on a review of a motion to dismiss, then you essentially have two individuals who are leaders within Kids First who have a contract with the department to ensure that they provide conflict-free services to families and children. These two individuals then identified a child that they wanted to have for themselves, even though they were not licensed medical foster parent care persons. They used their influence to convince the agency, Kids First, to transfer the children to them. They then, within the course of that proceeding, encouraged the Kids First to start termination proceedings, even though the evidence reflects that the parties had been waiting on genetic testing results. They then hid the fact from the court of the conflict and hid the medical test results, hid the fact that the child continued to need medical treatment, and in fact testified before the court during TPR proceedings that the child had no medical problems at all and that they weren't interested in adopting the child.
Did the trial court find, was the trial court under the impression that there was some importance to the sort of idea that the child suffered severe injuries before shelter, but then suffered no injuries as far as the court knew? Suffered no injuries after the shelter?
Well, that certainly was a critical issue, because what was portrayed to the court was that everything was, the child had injuries before in the care of the parents, and then after that, the child had no subsequent issues. And that was, we would assert or allege that was not the case, and that was a part of the court's decision. Another part of the court's decision was that it was represented to the court that the Frains were not going to adopt the child, and the child would actually be placed with relatives. Because if you actually read the TPR judgment, the court doesn't say that it found that any of the parents specifically caused this harm. It basically said, I don't know which of them or either of them did it. I just know that in the presence of the child, this harm occurred, and so for the best interest, I'm going to terminate the parental rights. But the court also noted that there were relatives who were interested in adopting the child, and the child took that into consideration in making this decision that this child would be placed back quickly with her relatives. And that not based on his findings, but that was also based on the testimony given by Mrs. Frain, who testified at the TPR that the child was healthy, and they made the representation that they didn't intend to adopt, and the caseworker made the representation to the court that the child would be placed with a relative.
I guess I'm just trying to get a clear sort of picture as to why one of the allegations is that the Frans essentially hid the fact that the child still had health issues.
Mm-hmm.
And maybe I think maybe there's even an allegation that they affirmatively lied that the child was healthy
Right.
after shelter. And so I'm just trying to get a very clear answer as to why would that matter in this sort of in the emotions.
Well, it's that I mean, I guess what I would say is that's just part of the issue. The real issue is that the department had a contractual and statutory obligation to provide conflict-free services. Basically, the statutory and administrative rules precluded someone who had a actual or perceived conflict of interest from being involved in the placement of the child, exactly for this reason, because then that person could use their influence behind the scenes to direct what occurs with that child, direct what occurs with placement, direct what the timing of the TPR. So in violating...
I guess what I'm trying to find out is, did the trial court ever indicate expressly, all right, or are you assuming? But are you assuming that the trial court considered the fact that the child was healthy after the shelter? Or did the trial court state that expressly?
The trial court noted that fact. I don't think the TPR expressly stated that I noticed a difference between the child's health before and after, but he did note the testimony that was presented. If that is the court's question.
But certainly, if the child's health sort of remained the same, or if the child continued to have health issues, that would have been relevant, right?
Yes.
In the proceeding.
That would have been relevant, as well as the genetic testing results that were not disclosed during the TPR. So to sum up the first argument is that simply 63.182 did not bar the civil action for damages. And if you agree with that conclusion, then we believe the proper remedy is to reverse the dismissal and remand, because the trial court's order, she dismissed the third amended complaint, but she plainly intended to allow the plaintiffs an opportunity to file an amended complaint. However, in doing so, she imposed a limitation that they could not raise any allegations regarding or related to the 2017 dependency proceeding. So then that placed the plaintiffs in a hamstrung position where they were essentially trying to come up with claims that basically ignored critical facts that really are relevant to the entire proceedings.
If we agree with you and remand,
Right.
you want to be free to replead. You don't want to be tied only to your fourth amended complaint, correct?
Correct, Your Honor. One, because that's what the court intended, and two, after the order was entered, what had happened in this case is the department and the kids first had been delaying discovery that we had requested, and it wasn't until after this order had entered that they released 12,000 documents and emails that were relevant to this claim, and that we believe we
You've
can...
got 4 minutes left for rebuttal. You can use your time however you want to, but if you want to save some time for rebuttal.
I'll save the rest of my time for rebuttal, Your Honor.
May it please the court, I'm Susan Levine. I'm here on behalf of the adoptive parents of the young child, R.A.W., who she's called throughout the pleadings and briefs, and the adoptive parents are here with me as well. The issue on this appeal is whether or not Florida's statute of repose in the adoption chapter 63 would be an absolute bar to these civil actions for damages that are brought. See, the child was adopted in 2019 and the parents' rights were terminated in 2018. And so, although we're looking at the text of the statute and how and whether it applies, it's important to note a few things. First of all, the parents who were represented by counsel during their TPR trial waived their right to appeal. They had private counsel, they chose not to appeal.
But isn't that one of the allegations they make, is that the Frains encouraged their counsel to tell them to waive the appeal? I'm not saying they did that, but isn't that an allegation in the complaint?
It is an allegation.
Well, and if that were true, how can you say, oh, well, they waived their appeal? If they were coerced through their attorney, who was encouraged, coerced, whatever the word is exactly in the complaint, that's okay? Or is that actionable?
I wouldn't think that that would be actionable. I think, Your Honor, that that would be a question of advocating for a client.
Did they
Yeah.
offer the lawyer, offer the lawyer anything to make it settle?
No, Your
According
Honor.
to the
According to the allegations,
According to the allegations, the lawyer, like every lawyer, gets paid when they take on a case to terminate parental rights or defend against it. And the later allegation in the complaint that the agency paid money to the lawyer to then finalize the adoption is $1,000 that the state gives anyone, DCF pays anyone through the agency when they finalize an adoption.
is there an allegation that the lawyer was offered cases in the future? More cases, more work?
There is an
Okay,
allegation.
there is an allegation.
Yes.
That's kind of outrageous, is it not? How is that not, I mean, if we're talking about the emotional distress, how is it not outrageous for, first of all, who would have made that offer to the lawyer, more cases going forward? Who would have made that offer?
I believe that
According to the allegations.
I believe that the allegations stated that the attorney who represented the Frains after the TPR was already finalized, or was already entered by the court.
In order to get the grandparents to settle.
Right. I believe that this is a situation where a
But
gamble.
the Frains lawyer, the allegations are, again, we don't have any idea because nothing's been proven, right?
Correct.
But the allegations are that the Frains lawyer offered opposing counsel work in the future if he could get grandparents to turn over RAW.
Your
Yes or
Honor,
no?
I'd like to clarify, because there's an allegation that when the attorney was representing the birth parents, that attorney, who was the same attorney, was coerced into it's alleged that he persuaded the attorney to not have his clients, who were the birth parents, seek appellate relief. Later, there's an allegation that after the TPR was entered,
Right.
and after an ARC hearing decided in the favor of the grandparents to adopt both children, that the attorney again influenced that same attorney to convince them that they should not appeal.
By offering work, additional
Your-
work?
no, Your
okay.
Honor.
Did I mix that up?
Excuse me?
Please clarify the allegations for us then.
I believe in that situation, they threatened, the allegation is that the Frains attorney had filed under the then available avenue under administrative law, filed an ARC appeal. And so the ARC had decided that the grandparents should adopt both children. And they exercised their legal right, the Frains did with their attorney, to file an administrative appeal under Chapter 120 of the ARC's decision. And the allegations are that based on the bullying of the Frains attorney, the attorney for the grandparents, who was the same attorney who had represented the parents, caved to that and counseled his clients that it would be risky, because if it did go up on appeal through the administrative process, it would be possible that the ARC decision could be changed and that the Frains would wind up with both children and not just the one. Is that clarified for you, Your Honor?
I read somewhere in the record, and I'm not finding it right now. I'll find it in a minute, I'm sure. But I'm trying to get clarification. I thought I read that counsel was offered something.
In the original case against the birth parents, in the TPR case, there's an allegation that if the family did not, that it was purportedly told to Elrod, who was the attorney, that if you don't appeal this, if they don't appeal this, we'll send more cases your
Okay,
way.
so that was, it was the first time, it was for the appeal, where that allegation is being made.
By the parents,
By the parents.
birth parents.
All right, and these are all just allegations, but I'm trying to sort out which allegation is which. So-
Correct. And, Your Honor, I'd like to point out, in this context, a court terminates parental rights based on clear and convincing evidence that one of the grounds for parental rights has been met. Here was a child who presented with 15 or so broken bones at the age of 3 months. The child was placed in medical foster care, and there was a hurricane, and during that hurricane, the medical foster parents who had that child had no power and no water, and so that's where, Your Honors, my clients came in, and as involved persons with the agency, stepped up in an emergency and met the child because they fostered her for a few days while there was no power or water in the medical foster home that had been housing her prior.
So they hadn't been to the hospital to see the child prior to that time?
That is an unproven
Is that an allegation?
Yes, it is.
Okay.
Counsel, I think everything we say here today is
Yeah.
about the allegations, because we all know that there hasn't been a trial, right? There hasn't.
Correct.
None of this has been proven. So when we're solely talking about allegations, because that's all we have. But that's relevant to whether or not the complaint should have been dismissed, right?
In a sense. In one sense, it's relevant to the intentional infliction of emotional distress claims. However, even in those situations, case law holds that even if the conduct is malicious or tortious, that doesn't necessarily mean that that rises to the level of outrageous conduct that cannot be tolerated by society. And I would purport that in the system of foster care and the way the privatization has happened in Florida, foster parents are involved in cases. If they're active and involved and volunteers in the agency, they are going to know when children come into care because they're going to be assisting the lead agency in this case, which was KFF, in helping those children find homes through the available licensed homes that were there. And the idea that there was a conflict of interest, to me, the worst one could say is that the Frains did not disclose to the birth parents or the grandparents, who were then competing applicants to adopt, of their connection with the lead agency. However, the DCF attorney was aware of that.
Was the judge aware of it?
The judge did not become, I don't believe that the judge was aware of it at the time of the TPR trial, but
When the judge found out about it, didn't the judge immediately say that's a conflict of interest?
that was when,
Yes
due
or
to
no?
other
Yes or no?
events, the second child, RW, who had been adopted by the grandparents, came back into care
When
because
the trial court first found out about it, did the trial judge not immediately say, that's a conflict of interest? Am I misremembering the
Is
record?
that the same judge or two different judges?
I believe it was a separate judge.
Okay, there was
I could be mistaken,
a
too.
subsequent judge?
Judge
Yeah,
O'Connor, I
I'm not
could be
sure.
mistaken.
But I would purport that the TPR entry of the TPR is based on proving by clear and convincing evidence that the grounds for TPR have been met.
Except for medical health of the child was allegedly withheld, was allegedly hidden. That's what the allegations say.
The allegations say, but the TPR judgment itself contradicts that. The TPR judgment says that the child experienced no additional broken bones.
Wouldn't that be, how is that inconsistent with an allegation that the child's health condition was being hidden from the judge?
Your Honor, the Department of Children and Families, the guardian ad litem, the caseworker, everyone visited the child and is aware of the child's. health. The foster parents don't have an obligation, Your Honor, to,
We can't decide whether or not these allegations are accurate today. That's not what an appellate court does. These are the allegations, though, and the complaint was dismissed. So all we can do is look at the allegations. And so what I'm saying to you is, the allegation is, hid the conflict of interest, hid the medical situation for the child, lied about the child's health, hid the genetic testing, influenced the lawyer, right? Those are the allegations. I have no idea if any of that's true. None. But the allegations are there, and that's all we have to go on when the complaint is dismissed, right? So how are we not getting into outrageous conduct with those, if all those allegations are true, how do those allegations not make out a complaint for emotional distress?
I would contend, Your Honor, that there was no duty owed by the foster parents to present this information to the court. The responsibility was on the attorney who adjudicated the case and defended the parents. And the parents had no explanation for the broken bones. And the reason that the court was not able to say which parent it was is because neither acknowledged having harmed the child, and since they had both told the court that they had had exclusive care.
Again, counsel, one of the allegations in the third and maybe the fourth amended complaint as well, but certainly in the third, is that the Frains represented that the child had needed no further medical care and that was not accurate. I mean, if they are able to prove that, would that be actionable? Or is that okay?
I would argue, Your Honor, that the clear and convincing evidence standard was based on that the child presented with with broken bones, and there was no explanation from it, and geneticists testified that at most the
Well,
child...
there was a conflicting
Right.
explanation for it. I thought that certainly the birth parent's physician or the child's physician said, in his opinion or her opinion, I don't recall which, there had been no abuse, that the child could have broken some of these bones during the birth process and so forth.
Your Honor, that is correct, but that was not a medical expert, that was their pediatrician.
Right, but didn't that pediatrician deferred to the geneticist, but it was not a full genetic test, correct?
No, the full genetic test was done, and when the papers were faxed to the court system and to those involved by a third party, by the Nemours Health, it showed that a page was missing, but the relevant information was there that showed that if a child has only one of two of the recessive genes, then the child does not have that genetic disorder. Because if the child had both recessive genes and would suffer from that disease, the child would not have survived to date. And so there was those findings and those conclusions that were made in the final TPR judgment stand. There was a time to appeal that. There was a time to bring a collateral attack on them. None of those were ever done or ever done timely. This case came up to the court on about 6 or 8 post-TPR motions that made the same allegations and were all found to be untimely. Also, this is the 5th attempt that was made in trying to determine whether or not a pleading would withstand a cause of action. And if the statute of repose means anything, and if you look at the broad language in the statute of repose, it is unlike any other statute of repose I have ever seen. It is very expansive that says, despite the statutes of limitation and despite other statutes involved, a claim that vacates, sets aside, or otherwise nullifies. And to otherwise nullify something means to do something to the findings that were found within
Oh,
the
that's not-
judgment.
Counsel, that's just not what it says. That's just not what it says. You stopped short of the critical word there. You said vacate, set aside, or otherwise nullify. It says nullify a judgment of adoption. It doesn't say nullify facts, factual findings, any of that. It says nullify a judgment of adoption. How do you get around that?
Well, Your Honors, if you look at the word nullify, nullify doesn't mean only to take the judgment away. Nullify means to somehow lessen the impact or the validity of it. Nullify isn't the same to otherwise nullify.
A judgment will be, as far as I can tell, that judgment will be fully valid if the emotion, for instance, if the emotional distress claim goes through and they prove it and they get a judgment for damages on that claim, the judgment of adoption will continue in full force and effect.
And their parental rights will remain terminated, won't they?
Your Honor,
Regardless if they get $1 jillion or they get $10.
One would hope that would be the case.
Well, why
That's what-
wouldn't it be?
that's what the
How
statute
might
says.
not be the case?
Based on the number of attacks that have been made directly to overturn the final judgment of adoption and the allegations and pleadings within the subject complaints themselves, they continue to state that the children were wrongfully removed and that their rights were wrongfully terminated.
Well, there's something to be said for that when the medical experts, now that the full report is out there could be a single recessive gene causing a bone problem, correct?
Correct, but that was
these
known at
people
the
aren't
time.
making
That was
something-
known at the time, Your Honor.
These people aren't making something wild up. I mean, it's not like they're pulling stuff out of thin air in terms of whether there was conflicting evidence and whether something went on, but regardless, that's fine. They chose not to appeal under what they say are improper circumstances, and under this statute, I think it's pretty clear, at least to me, that the adoption judgments will not be set aside, nullified, or otherwise vacated, and likewise, their parental rights won't be restored whether they get 0, 10, or $1 jillion. I mean, they may keep trying, I understand that, but in terms of setting aside the TPR or setting aside the adoption, I don't see under that statute how they can, and they say they're not trying to anymore.
I think, Your Honors, if you look at the words of the statute that say that any cause of action of any kind based on any ground under any other, notwithstanding all of these other statutes of limitations, that statute of repose is intended to protect the adoptive family moving forward
It's not
and to
what it
protect
says.
the
It says
privacy.
you cannot get rid of, you cannot eliminate or change the underlying adoption judgment or the TPR.
There were other, Your Honor, there were other reasons raised in both the third and fourth amended complaint of failure to state a cause of action and failure to plead necessary facts that would equate to the cause of action.
I agree, but that has nothing to do with the statute of repose.
Perhaps not, and if I may just conclude, these plaintiffs were given 5 times to plead a cause of action. They, at each turn, brought up new causes of action, hoping that something would stick. This court can look at the allegations that were made that include the 2017 events, because my opponent believes that the pleading of the Fourth Amendment complaint was restricted by the
Go ahead and wrap up, please. We don't need to.
this court can see what all of those other actions are and were, and thus the other reasons to affirm. It's an abuse of the pleading process, failure to follow the court's admonitions on how to plead, and failure to state a cause of action.
All right, thank you.
Thank you, Your Honors.
And if you'll give appellant another minute, please, on rebuttal. 1 more minute.
May it please the court? Your Honor, the outrageousness of this case is clear, and as the court noted, this is a motion to dismiss. The only issue is whether the allegations set forth claims that should be pursued, and as we asserted, the only real issue that should be decided is if 63.182 barred the civil damages, which it did not. I did want to point out to the court that the adoption applicant recruitment committee did determine that the grandparents should have been, both children should be placed with the grandparents. The Frains then, without any disclosure to the grandparents, filed a separate appeal. They didn't serve a copy to the grandparents or their attorney, seeking to get that ruling reversed and actually get both children. When that failed, they then directed Kids First to then put pressure on the grandparents, basically telling them that if they didn't basically walk away from their efforts to get Renaya, that they would then try to take Rodney. The coercion and the influence that these people exerted on the Williams family was outrageous and ridiculous, and we think that we would certainly ask that the court would reverse this dismissal if it determines that the statute didn't bar these civil claims.
Let me ask you a question about something just a
Yeah.
little bit different. In the 2019 proceeding regarding R.W. the third,
Yes, sir.
was that before a different judge or the same judge?
So the conflict, it was before a different judge. The conflict of interest was not discovered until that 2019
That was not
proceedings.
Judge Cox, that was a different judge?
A different judge, and once it was discovered, that was noted, the court immediately recognized, hey, that's a conflict. You should not be involved with this child, which they knew from the beginning. That's why they were hiding it. They knew they shouldn't have been involved with this child, and that they had a duty.
I don't want to eat up all your time, I
Yeah.
just wanted to make sure.
So they were aware that they had a duty to not be involved with this child. They knew the rules precluded it. They hid that fact, and then they used their influence to direct what occurred with this child throughout the entire proceedings. And they are subject to civil liability. The legislature held in 409.933, there's a specific statute in which they increase the limits of liability for lead agencies and employees and agents of lead agencies. And basically, instead of the normal cap, they raise the cap to $200,000 and $300,000. And if it finds that the actions were intentional, it basically eliminated the cap in its entirety. Because so the legislature intended for lead agencies and their agents and employees to be liable if they don't follow the law and administrative rules regarding to services for children. And that's all my clients are seeing. And the last point I would make is that this case is not about trying to reverse the termination of criminal rights. My clients recognize that opportunity is gone. But what this case is about is seeking recovery for monetary damage for the actions of the Frains, both during the TPR and after the TPR. So even after the judgment was entered, the grandparents had a right to visitation. They were denied that right. The siblings had a right to visitation with their sibling, and they had a right to continue with that relationship because the statutes and administrative rules that controlled said that the department should have been placing those children in the same care placement, which they didn't, solely because of the involvement of the Frains. So those are the types of actions that we're seeking damages for, and those are recoverable under Florida law. And the only reason this case went off the tracks is because the trial court concluded 63.182 barred those claims. We would ask the court to reverse remand and give us an opportunity to amend, and with the understanding that 63.182 would not bar the claims.
All right, thank you.